Good afternoon, everybody, and welcome to the final Professional Care Workers Week panel of today. This session is focusing on the legal rights of care workers. Before I get round to allowing our panelists to introduce themselves, I wanted to say a big thank you to Freeths for sponsoring this session. We are incredibly grateful to them for this sponsorship. For those who are worried that they may not be able to view this in live time, please do not worry. This session is being recorded and will be uploaded to our YouTube channels. So I will pass to our first panelist to briefly introduce themselves. Janika, I will go to you first.
Good afternoon, everyone. My name is Janika Patel. I am a solicitor at Freeths, based up in Manchester. I have experience of defending employers and assisting employees in a number of sectors, including the care sector, for the last sort of 5, 6 years. Glad to be here. Looking forward to a good discussion.
Thank you so much. James.
Good afternoon, everyone. My name's James Rycroft. I'm the Managing Director of Vida Healthcare. We have 300 beds and 615 staff currently up in North Yorkshire, and we look after people living with all stages of dementia. So glad to be here.
Thank you so much. John.
Hello, my name's John Healy. I've been a care worker for nearly 20 years and have a background in learning disabilities and mental health issues. I used to be a union representative and have taken an active part in advocating for the social care workforce, and I'm on the advisory board of the Care Workers Charity. Thank you.
Thank you, John. And finally, Oliver.
Hi, everyone. My name is Ollie Spratt. Like Janika, I'm a senior employment lawyer based at a firm called Aiken down in London, and I also have experience working for employers and employees in a variety of employment law related matters, including in the care sector as well. So it's great to be here.
Thank you very much. And once again, thank you all for taking time out of your day to be part of such an important panel and discussion. So one of the first questions that I have, and John, if it's okay, I'm going to direct it to you. Have you ever felt unsure about what your rights are as a care worker, whether that's around contracts, breaks, or pay? And if you are unsure, where do you go to for trusted advice and or support?
I would say that that's something that has cropped up on a regular basis, depending on which employer I've worked for. Normally, it's down to the management style of the placement that you're in. Normally, being short-staffed is quite common, so things like breaks can sometimes, not happen. Depending on the management style, might be how you could broach questions. In some management styles, it's very difficult to actually find out what your rights actually are, and you'll get the comment that we do it this way here because normally down to resourcing or staffing. I have worked in some places that are very efficient, very well run, that have a very good team ethos. I've worked in some places that weren't run in such a good way. If I was looking for guidance on what my rights were, or if I had a difficulty, then I would say I would probably approach my line manager. Failing that, it would have to be a union representative to seek guidance and see if there was an issue that I could actually do something about. A lot of people, I don't think, are aware of what their actual rights or the contractual protection is. And I would advocate for anyone to get a copy of their contracts and ensure that they're aware of what they're entitled to and what they're able to do if they do have concerns, and certainly to seek professional advice for guidance and anything else that happens. And if something unfortunate happens, to always seek guidance from a legal practitioner and ensure things are documented and you have a paper trail, as they say in care. If it's not written down, then it didn't happen.
Thank you so much, John. And we do hear that a lot of, writing everything down and documenting everything is an incredibly important part of care workers' role. Janika, I noticed you unmuted. Did you want to come in at all?
No, it's good to hear John John's perspective on things and different management styles. A lot of what we see as lawyers when things get to us, these are people-centric issues, and a lot of them can be resolved in an easier way, even if the problem is quite significant, by way of, communication style, support, empathy, and it's rarely down to the legal issues. It's talking to people, on a human level, and discussing those issues before they escalate. But there are other ways, I think. Line managers, yes, if they've got good training and things like that, and they can deal with these situations. But perhaps for workers, if they aren't happy with the result that they get from talking with their line manager, looking at escalating via their employer's HR function, they can do that. But there are also other platforms available, such as ACAS, for example. Now, ACAS, for people on the webinar that might not have used those services before, it's an independent public body that offer free and impartial advice and guidance on the rights, rules, and best practices. And it's not just for employers; it's for employees as well. And ACAS, they've got great website. It's very neutral and balanced, and it helps provide lots of guidance and sort of digestible pieces of information in respect of your employment rights, how to go about trying to resolve workplace disputes, and just understanding those procedures. They've also got a free helpline as well, before any sort of issues need to escalate into the sort of litigation realms, as it were.
Thank you so much. And Ollie, I also noticed that you unmuted. I don't know if you wanted to add anything to that, or
Janika stole my thunder completely by talking about ACAS. It was, and I couldn't agree more. I think it's a fantastic body, a really, really helpful resource, and in fact a resource that has some, in some areas has legal, power as well, insofar as employers are bound to comply with, as a minimum, for example, in the case of disciplinary proceedings, following the ACAS guidance. So ACAS is a really excellent resource, and as Janika said, we hope always that things don't need to escalate that far, but should there be an issue that is sort of unresolvable, ACAS also serves a purpose of providing or facilitating what's called pre-claim conciliation, whereby they effectively try and act as a mediator between the employer and employee to try and resolve a dispute before it has to be launched, or the employee wants to launch it. So really, they are a fantastic resource, and I completely echo Janika's points there.
thank you. And John, I will hand back to you before I go on to my next question.
I would totally support what's been said by the previous two speakers. I would say that care workers should be confident in saying that they don't agree with things, never accepting anything along the lines of that's how we do it here, or being told to do something. They can always challenge it. And one of the things I would advocate is the ABC is don't believe anything, check everything, and make sure that what you're being told is actually legitimate, because sometimes corners do get caught. I would also advocate the use of something like the Citizens Advice Bureau, the Health and Safety Executive, or CQC, or the safeguarding procedures if there is anything you're not sure about and you might need to whistle blow. But I do think it's something that care workers need to self-advocate for themselves and the people they care for and their co-workers.
Thank you, John. Now, James, I also actually have a question for you, because I can imagine, as you, in the introduction, you said, you've got over 300 beds and over 600 employees. I can imagine that at times it can be quite overwhelming with various changes in kind of like policy or legislation to constantly, keep on top of understanding, the rights of those who work for you. What is it like for you, kind of be having so many people in your organization, and also where do you go for kind of trusted support?
To the pub, and it's emotional. No, I'm joking. I, um, we as a responsible thing, I think it's a shame, and I understand it, by the way, John. But I do think it's a shame that there's some operators out there that do have this kind of off the record, that's the way we do it here, because the law is so strong. And you're right, Olivia, if you trip up, you will get bitten. I do have some controversial things to say about employment law, which probably won't go down well, because I do think it's as a result of there being some operators out there that are a bit untrustworthy. I do think that that's resulted in employment law being weighted a little bit towards the employee and a bit too much at times. Therefore, it's very easy to take someone to court and often very hard to defend. And I'll say that as an operator because I've been on the front line of it and seen it in its true form. Again, I appreciate that that's controversial, but as an operator, we're utterly transparent. We have an HR department that's upfront, shares absolutely everything through various platforms within our business. Like we have our own app and we share all of that, plus through our supervisions and our appraisals, rights and expectations are always explained. We're always in line with the law, and also emerging practices as well. And I think, in that respect, I think that's probably why, because we are so open and so have everything set so that it's there and on a plate. And I think that's probably why our retentions, I think we must have one of the highest retentions, lowest attrition. That's the word I'm looking for. Because we're about 7%, which I think the average is about 30 now in our sector, which is terrible, really. It's a terrible, terrible figure to have. But yeah, there's my sort of thoughts, be good, bad, indifferent, controversial. That's just where I stand at the moment, because unfortunately there are some employers that might not go by the rules as such, but it's very difficult when you do go by the rules. And I think sometimes some of the emerging legislation opens that up for more people to sort of take action against those people and get through without them necessarily being valid claims. So that's where I am.
Thank you for sharing, James. John, I'm just going to head back to you because obviously one of the things that you spoke about was, you have worked for some companies that have been really great and diligent, and you've also worked for some companies that have perhaps overlooked your rights as an employee. With those examples, what rights of yours do you think were most overlooked? Or not respected in your day-to-day work and in your experience? And
Sorry.
oh, sorry, go
I was going to
ahead.
say, first of all, I'd like to just reinforce the gentleman that was just speaking. There's a lot of good employers out there, and I think a lot of the good things are overshadowed by very small amount of bad practice that does give the industry a bad name. There's a lot of very good employers and a lot of very good employees. I would say, as a care worker, you're the front line of the corporate face of a company, and you represent their interests through vicarious liability or various ways that you are responsible for your actions and your inactions. And I think that's where the law comes in to hold the care worker and the company to account. With regards to experiencing things from some of my past employers that haven't been so good, that's the assumption that you'll do everything that you're told and you might not question things, which is the complete opposite, really, of what a care worker should do. The assumption that there's lots of goodwill that you'll fill the gap when there's a staffing shortage. Working unpaid overtime is a big thing. Doing delegated tasks which you aren't necessarily trained for, which, due to the current status, some of the tertiary healthcare sector support services, there perhaps aren't enough district nurses to change dressings, and you might be given informal training and be expected to change wound dressings or administer nebulizers and other quite invasive drug therapies. That's all marvelous when it goes well and it's not a problem. It's when it goes wrong, it comes down to the person who signed for the medication that was given to the wrong person or the wrong medication, and there can be some very sort of really bad fatal consequences, and ultimately it might end up in some sort of legal investigation involving the coroner or the police. So I think that the expectation that the care worker can cover every situation is one that is assumed, and a lot of things are left to care workers to sort out. And that's where I think the model of good management is required. If that answers any of your questions.
Yes, it did. Thank you, John. And I think something that you highlighted there actually kind of leads quite wonderfully onto my next question. So in May of this year, the Care Workers Charity launched the 2025 Wellbeing Survey, and we garnered responses from over 2,000 care workers across the UK, and we asked them a range of questions surrounding financial wellbeing, mental wellbeing, etc. And we also asked a lot about their experiences in work. From the responses, over 500 individuals said that they worked up to 20 hours of extra unpaid time each week. And I would be really interested to know from a legal perspective, what is the legal recourse around paying for overtime that isn't in the contracted hours, and what options should be available if care workers are not compensated for overtime or extra hours worked? Janika or Ollie?
Yeah.
Yeah.
Yeah, no, I mean, that's a staggering statistic, 20 hours a week. Now, and there's a variety of legal, or there's a variety of legislation and contractual protections in place for the employer and employee when it comes to working time. We've had in this country the working time regulations in place for since 1998. So it's a very established set of legislation, which, among other things, imposes rules around how many hours a week a person should be required to work. There are some opt-out entitlements, but 48 hours is generally the limit, and also the entitlement to rest breaks and sufficient breaks between shifts, etc. Appreciating that that's not always practically possible, John, as you say, but to the extent that, well, stepping back, all employees and workers should be issued with at least a statement setting out their main contractual rights and entitlements, including working hours and pay. If you are required to work overtime or sufficient amounts of overtime, unless the contract states otherwise, and even in those cases, I think there's limits to that, you should be paid at least the national minimum wage for the work that you're actually doing and the work that you've actually done. And so, to the extent that you have, and as I say, these statistics of an extra 20 hours a week is obviously a significant amount of time for all these people to be working. Averaging that out over the relevant reference period, which is normally about a month, that means that if you are therefore paid less than the national minimum wage for each of those hours, you would be entitled to claim for that. The process for claiming is, yes, there are many protections for employees, but equally there are limits in terms of how easy or straightforward it is to make those types of claims in the Employment Tribunal, which is why speaking to ACAS or your Citizens Advice Bureau is a good place to start. But ultimately, there are rights and obligations in place to make sure that individuals are paid for the work that they do, and not the other way around. I would note that, and I think this is to one of James's earlier points, and to your earlier question, the law is constantly changing, and as employment lawyers, we are very interested to see at the moment what is set to be some of the the most significant employment law changes in a generation with the implementation over time of the Employment Rights Bill. And it's been in the press quite a lot. There are some serious changes coming into effect. One of those changes, which I think is going to be relevant in this particular scenario, and I'm interested in Jannika's thoughts as well, is the introduction of what's going to be known as the Fair Work Agency, which is going to be a body that has certain powers and enforcement powers, including in respect of low pay and failure to pay. Now, that we don't know when that body will come into force or exactly what its powers will be, but I think that's going to be to the extent there are those unscrupulous employers out there who are, pushing their employees to do more and not paying them for it. Having such a body in place should certainly, cause them to think again and realize that there are going to be repercussions if they don't.
Thanks, Ollie. Sorry, Olivia. Just wanted to touch on those points. Going back a step in terms of the overtime issue, it is common knowledge, isn't it, that every care worker, or most care workers, are, just because of the supply and demand situation, do work quite long hours, do work in excess of contractual hours. The other consideration for care workers to bear in mind is if they are working these regular sort of overtime, and I think, John, you said 20 hours a week, then there is a financial consideration to be had in terms of holiday pay. Okay, and you're probably thinking, well, what does overtime and holiday pay have to do? Well, if you're working more hours and you are entitled to take some time off, what is the rate of pay that you are receiving for that time off? And people will assume, and it has been the position for a very long time until only recently, that okay, I earn, for example, £250 a week, and if I take a week's holiday, that will equate to £250 worth of holiday pay. But if I earn £250 a week on my normal hours and then work 20 more, then the law does actually say that needs to be factored into your holiday pay calculations. And if you, as a worker, do not believe you've been paid correctly for that time you've had off, it doesn't factor into those calculations, the extra hours that you've worked, then there is recourse there. Firstly, speak to your line manager. If that doesn't yield any results, that there are opportunities for employees and workers to raise a complaint or a concern via the grievance process, which could help assist and resolve any issues in respect of pay. And then if you believe you have no choice but to leave your employment, or you're leaving for other reasons, and you think at the end your holiday pay hasn't been calculated correctly, you can take then legal action by speaking with ACAS and then lodging a claim. So that's in respect of the overtime issues and the sort of consequences of not being compensated for overtime. The other consideration in respect of that is, could employers offer time off in lieu in respect of overtime that isn't paid for? Again, James will probably be saying, well, we need workers in, we need the hours to be worked, we need, the people we support need to be supported. So then offering time off is probably counterproductive to what we need in the services that we want to offer. But like Oliver said, there are lots of changes that are on the horizon, and only as of actually, I think it was yesterday, that we've had some more developments on new employment changes. Again, lots for James and providers to have to then get on top of. But this Fair Work or fair pay agreement is something that is going to be in place to assist adult social care workers, and it's an agreement that hasn't yet been implemented, but the aim is the government want to enable a sector-wide agreement in respect of setting minimum standards for pay rates, working hours, holiday entitlement, training and development. I think John touched on instances of previous lack of training and doing all the tasks, health and safety provisions, which then intrinsically tie into that, and then safeguarding. And this fair pay agreement matters for care workers because, like we all know, the care sector is categorized by high turnover and low pay, which the low pay is down, to a lack of required funding, as opposed to a provider's choice to pay that low pay given the work that is so invaluable that is carried out. But it's not been implemented yet, this fair pay agreement. It's all a work in progress. There aren't any fixed dates, but we're probably looking sort of late on 26, 27, which is as fast as these things go, really. But yeah, that's my 2 pence, as it were.
Thank you so much. That's really interesting. And James, I noticed that you had your hand up. I don't know if you wanted to come in at all.
Yeah, I mean, just on the fair pay thing, I'm all up for paying care workers and any member of staff above and beyond. That's what we do here at Vida Healthcare. It worries me about the fair pay thing because I think they're looking at maybe 15, 20, I think is a rumoured as a minimum wage. I may be off kilter there. But if that's the case, that's going to have a significant impact. As I say, on the one side, it's amazing. The other side, how are we going to pay for that? Because for me, that would add £6 million to my wage bill, which therefore is, we've got to pass that on in some way, which sort of defeats the object to a certain extent because the councils don't have any money. But I was just saying, from my point of view, and I can only really speak from Vida Healthcare's point of view, but in terms of overtime, again, we lay out very clearly in our contracts, and it's explained the hours. If somebody wants to work over those hours, they then will sign, forgive me, what's the legal term, the document that they'll sign to go over the hours that they're
out.
Yeah. And they also get paid 20% extra per hour for every hour that they work overtime. So there's a kind of precedent set as soon as somebody joins us. Because the last thing I want to do for financial reasons is to get agency staff in. So for me, financial sense, I pay 20%. If I get agency staff in, I can be paying 50% more. So, and then therefore I don't get the familiarity of staff, which is so important for my service for people living with dementia. So we set our stall out right from day one, and therefore every single person in fact, they're fighting often to get paid that 20% extra because it's a real justified and deserved amount of money that people should be taking. But it's very disappointing I can't believe those stats of people getting 20 hours a week. I mean, it's just phenomenal. The area that it's difficult to monitor in certain circumstances is those that are on salaries and not on hourly rates. If they're working overtime, then it's difficult to try and do that. But what we have is a kind of open forum where people, if they do work over, obviously it's got to be justified. But then we'll either do maybe time in lieu because the salaried people tend to be more office based, and therefore it's not as critical for the residents, so they can take off that time. But we try and be as fair and as open, and as I said, people get paid a lot more to do that. So yeah, that's where we are at the moment. I think setting out people's stall and being fair without compromise is again probably why we have such a low attrition rate.
Thank you so much for sharing, James. And John, you've got your hand up, so I'll go to you.
Yeah, it's very refreshing to hear such a positive attitude from the employer side. And I think that's sort of very impressive. And it just sounds like you've got a very good view on the value that you place upon your workforce. I think there are lots of good employers out there. I also think that since the pandemic, I think the social care workplace has changed and is changing an awful lot, especially with these initiatives. And I think goodwill has been something that's been exploited quite a lot, so that these things have occurred where people are working unpaid hours, especially if you have a domiciliary care job where you travel between appointments where you're not paid. So you might be out on the road for 12 hours, but only paid for 8 or 9, and you have time away from home that you're not reimbursed for. So with the cost of transport and things, you're effectively working for below minimum wage. I do think there's a lot of changes coming into the workplace, things like AI and digital work practices. So I think it's a work in progress, but I do think it's important that it is remembered that the core of this is based on the people that turn in, day out, that go above and beyond every day of the year. 365 days of the year. And I think, unfortunately, there are some people that don't get the same deal as others. And it's a lot of inequalities that can affect a lot of people. So I do think that there is a need for advocacy from the workforce, but also in cooperation with the employers, so that it's not a face-off, but it's all almost working in a partnership to get the best. Because I know times are difficult. I know the economy's having issues, and I know there's a lot of things that have come in that perhaps the care worker isn't aware of, such as national insurance contributions and other costs and aspects that perhaps they're not aware of. So I do think it's a complicated situation, but I do think it is quite promising, some of the things that are happening.
Thank you, John. Ollie?
Yeah, it was sort of a really interesting to hear, obviously from John and from James on both the employee and the employer side, and possibly a question for both of you guys that I think feeds into this broader question. I think, John, you mentioned you were involved quite heavily in union activity, well, not union activity, but as a member of a union, and so I'd be really interested to hear your thoughts, and also James, your thoughts in terms of your interactions as an employer with any employees of yours who might be members of the union, and how that can actually help the care workers and the organizations to work together effectively, if that's been a positive experience or not. Olivia, I hope it's okay that I asked that question. It sort of came to me as they were speaking.
Of course.
I hope you don't mind if I come in on this. I would say that when issues occur, it's not when something's gone wrong, and it's down sometimes to communication misinterpretation. I would say that currently the care workforce is not a professionalised workforce like nursing or the allied healthcare. And I think that's something that potentially could improve the situation for care workers. So they are part of a body that is represented at a national level in things like pay, conditions, practice, training, career planning, and the way in which careers can be developed over time. I think someone said earlier on that the turnover rate for some companies was 30+%. So a lot of money gets spent on training that then has to be repeated when a care worker joins another company. There is no follow through or compliance with any model that I'm aware of that means that could be transferred. So when you invest in your workforce, sometimes the investment doesn't always return because the care worker leaves. So I would say I think it's a very important dynamic to develop and to use communications and negotiations. And actually, I would say personally myself, I think the Care Worker Charities does an amazing job for an unrepresented, profession, as I should say. It's not actually regulated in any way currently.
James, I will hand over to you.
Yeah, John, I would agree that the Care Workers Charity do an amazing job. So thank you all to all of those people that work there are involved with it. I think it's just a brilliantly selfless setup. I also would also like to say, and I think it's really, really prominent that, and it's quite straight talking this, but I believe that any operator that doesn't believe that the workforce are the absolute lifeblood of their operation shouldn't really be working in social care, because I'm really lucky. I built my buildings. They're all nice and spangly and lovely and great places to be. But the service that we provide is absolutely nothing without the workforce. So for me, it's a simple thing. We have to look after people, and if we look after our staff, they look after our residents, and it's a very simple sort of ethos that we stick to. And it's a terrible shame that there are these you know situations out there where that clearly doesn't happen. Just in terms of working with unions, yeah, I don't really have so much of a positive interaction with that. But that's due to the fact that I would probably say we don't have very many cases against us, and therefore our interaction. So my opinion would be not really that valid. I don't think I can only talk about the ones that I've been involved with, which are not really worth talking about. I'm not really answering a question here, I know, but yeah, but I do think ACOS, for example, they do give a great support to workers who are, as you say, John, massively underrepresented. What's the word? Underrepresented. Is that right?
Underrepresented. Get out of cell. Underrepresented. I can't know.
It's one of those words that you've said so much now it doesn't quite sound like a word anymore.
Underrepresented.
Yeah, I can't. Yeah.
Underrepresented. I'm going to leave it there.
Right.
Thank you. One of the questions that I do have, and it's probably one for the legal experts on the panel, is that obviously one thing that John has pointed out, and one thing that we also point out as well at the charity, is that care workers are not a homogenous group. We have people with different experiences working in different settings. So how does employment status affect care workers' rights, whether that's to the likes of sick pay, holiday pay, maternity leave, job security? So, for example, we have heard from some care workers who are on 0-hour contracts who don't understand what their rights are within that realm. So could you kind of explain to me, how does employment status affect care workers' rights?
I'll kick off if you don't mind, Ollie. Okay. So we've got not all care workers are employees. Some are workers, and in employment law we've got employees, workers, and self-employed. In the care sector, we're predominantly going to see individuals categorized as employees or workers. The starting point is what is in the contract, the written statement of particulars. They're called employment contracts, but it might be you are a worker. What was agreed and discussed when the individuals were offered the job, and looking at the way the organization and the individual works together. People who are taken on as employees and have that employment status have more employment rights than their worker counterparts. They also have more obligations towards their employer. And when we're looking at the care sector, you may have, and this is where people may get annoyed with lawyers and the paperwork, is just because something is labeled one thing, if we scrutinize and look at how the individual and the provider work together in practice, that will give you a stronger indication as to whether someone's an employee or a worker. And if we think about what is likely to make someone an employee, factors such as they're required to work regularly unless they're on a period of leave. Work is always available to them. They can't just refuse to do that work. They will be paid and entitled to holidays. They will be subject to things like the disciplinary procedures. They have to give notice to their employer about taking certain types of leave. They can't just get someone else to come in and do their job for them, and the employer gets to decide how, when, and where that person does their work. A worker, conversely, okay, will will have it'll be a bit more casual. And so if you look at the contracts as a starting point, there could be terms used as casual worker, freelance, 0 hours, or something similar. But looking sort of deeper than that contract, they might not be required to have a regular working pattern. They might have very little obligations to make themselves available for the hours. They can pick and choose those hours of work, and the employer doesn't have to offer that individual set hours or any hours at all, looking at like a 0 hours contract worker. Now, that has implications legally, because if the contract is terminated by the employer, it's only an employee, a legally classed employee, that could have rights in respect of unfair dismissal. Okay, workers don't have that right, and a worker, therefore, there are job security issues and things to bear in mind. In terms of pay, if someone in the care industry is an employee, they are entitled to things like sick pay, statutory sick pay. If they are a worker, they could be entitled to statutory sick pay, but only if they meet certain conditions. Contracts are usually the starting point to iron out what they are entitled to, and those differences. Holiday pay for both employees and workers, but again, contracts will dictate on how that holiday pay is calculated. Lots of workers might have more of an irregular or variable working pattern compared to salaried sort of full-time employees. And then things like family-friendly type leave, maternity leave. So an employee has the right to take maternity leave. A worker isn't entitled to maternity leave. Okay, they may still qualify for statutory maternity pay, depending on their earnings and how long they've been with the provider, but not the actual a leave. And that applies across other family leave, such as paternity and adoption leave as well. Yeah, so there are some stark differences between the two, but in true lawyer fashion, look at the paperwork, see what that says, and then ascertain if that's actually happening in practice or not.
Thank you so much. That was really interesting, and I guess every day is a learning day, because I've now learnt the difference between, the employee and the worker. Ollie, I don't know if you wanted to come in and add anything to this.
No, I'm really pleased Janika took that one, because it's such a complicated and an ever-changing set of rules, and it's very, very fact specific beyond the contract, as she says. I think one thing that is being consulted on with regards to these employment rights changes is there's a desire to try and further clarify and limit those three sets of statuses, given the confusion that can arise. But certainly, as Janika says, looking at the contracts is a really good starting place. I would, I think it's worth, of course, bearing in mind that in most cases, whether you're a worker or an employee, the employer will normally be quite obvious. So, James, your employees will know that they are employed by you as part of, the organization. In the social care industry, where there are individuals engaged directly by individual families, for example, to care for an individual, and they're not engaged through an agency. In those circumstances, working out or understanding who the employer or what that relationship is, and who owes who the rights and obligations, can be a bit less clear cut, but no less real. So the fact that you are employed by or a worker of a family, for example, doesn't mean that you don't have the same rights and protections as other employees and workers. So That's just to remind people, if anyone is listening who falls into that type of category of worker or an employee, that you have the same rights as Janika's just explained.
Thank you so much. And I think it is important to recognise that, care workers have, like you said, Ollie, like different experiences, but they also have different care settings as well, which is really important to recognise. I think we've spoken about a lot already, and I'm aware that time is slowly slipping away from us, and I've still got a few questions. James, obviously, one thing that you've spoken about is, kind of being transparent and being open and being honest. Do you have any other forms of best practice to share with care providers surrounding, the legal rights of care workers?
We have I've developed one of the biggest things, not just to do with this subject, but with everything, is communication with staff. And we found that, as we got more and more staff, it was more difficult. We started off with texting systems and stuff like that. And quite frankly, I think we had so much to share that it gets annoying for workers to just get the phone pinging every 2 minutes with incredibly boring text. So we developed an app that is effectively like a social media platform that's got different streams to do with, HR or whatever that might be, and therefore we can send messages and keep people updated all the time, and it's on a familiar platform. So we use that to great effect. And we also have our academy, which we train people through, and in that we talk about everyone's rights. Is that the question you're asking? Is that just how we share our information? Yeah, we do that, and obviously at supervision and appraisals, it's a constant. I think what's really important to say is that it has to be a constant dialogue due to the ever-changing sort of field, the legal field. It's ever-changing, and there's always different things that you've never thought of before that come up. So we're in a constant dialogue between management and between staff, and hopefully we've kind of created this open culture where also it's really important that staff can feel that they can ask a question, something that they may feel controversial or, well, will that affect anything? And it doesn't. It's just people's rights. Either way, it's people's rights. And we, as an employer, we don't hold back on saying, what protects us as employers, and likewise for employees. And I think you can't shy away from any of that because it is what it is. So you need to arm people with the relevant, correct information. I don't know why operators wouldn't do that. It's just the law of the land, isn't it? You can't hide away from it.
Thank you, James. No, that's really interesting. I actually also had a question because one thing that we hear a lot from domiciliary care workers is they are unsure about their rights when it comes to payment for travel reimbursement between individuals' homes. Can you offer any kind of advice on what is available to domiciliary care workers for payment for travel in between shifts? I don't know who wants to take that one, Janika or Ollie.
Yeah, I can chime in on this one. The contract, again, I feel like this is a bit of a cop-out answer, but the contracts and policies and procedures in place about travel time, like you said, domiciliary care providers, times in between calls and appointments, those individuals might not necessarily have a fixed place of work and then going to have to spend time on the road between those appointments. That time is generally speaking, and I caveat that generally speaking, travel time, or is likely to count as working time for those workers, because they're in the process of doing work for their employer. To get from call A on one person's home to call B, they have to have travelled in that time, and then pay. Well, that then has an impact on pay, and then making sure that time is factored in for minimum wage purposes to make sure you're not falling foul of any minimum wage or national living wage laws. But the contract can set out, and some providers I've seen that I've done some work for may say, well, if the time traveling between A and B is going to be more than, say, an hour, and it's only going to take you 10 minutes to get from A and B, okay, which I know logistically is for planning purposes, rotoring and things like that. But sometimes that's the way it can happen. If you're going to have an hour in between, then should the employer then have to pay you for that full hour if you're not actually going to be traveling for that hour? And again, I feel sorry for payroll. I have to be honest, and rotoring, because we only see the dispute end of it at the end. Is not all of that is necessarily travel time. And therefore, I'm saying, the cop out answer, look back at the contract, because the contract can then stipulate those provisions. If you're going to be needing to be in between calls for longer than the time it would take you, then you could almost categorize those calls as different mini shifts within the working day. And if you call them mini shifts, then the employer then doesn't necessarily have to pay you for that full time in traveling. And if the employer is silent on the issue, then as an employee or a worker, you've probably got a challenge there to say, well, it's all travel time and therefore it's all working time. And so this is why we say we have to, as a true lawyer fashion, look at what the documents and papers say, because it is an issue that crops up. It is an issue that gains traction in the tribunals, and it's one of those for employers. If they've not got it right, then it can open up the floodgates, because not only will it likely affect one individual, it's probably going to affect a lot of the workforce. Yeah, I hope that answers the question.
Thank you very much. I'm also aware that we've probably got around about 10 minutes left. And there are a couple of questions that I wanted to ask. So obviously we've spoken about, understanding of employees versus worker rights. Say, for example, there is an employee who is thinking that, one of their rights is not being met. What advice would you give to them, and what legal recourse is available for them in accessing their rights? Ollie, should I go to you first?
I missed the most important part of the question.
So,
Sorry.
no, that's okay. So obviously we've distinguished between employee versus worker rights. Say, for example, there is an employee or a worker who believes that they aren't gaining access to one of their basic rights as an employee. What advice would you give them, and what legal recourse is available for them to access their rights?
Yeah. So, and thank you for your patience. Janika's already touched, very clearly and helpfully on, I think, the internal recourses, particularly if you work for a larger organization. Look at your contract is the starting point to know what your entitlements are, but also make sure that you are aware of and familiar with the relevant policies and procedures, including, for example, in relation to if you need to bring a grievance, and at what point in time you bring that grievance, and what the form and nature of that grievance is, and who you bring it to. And it's very important as an employee to make sure, not just to try and resolve the issue, but also mentioned earlier, the ACAS 25% rule. If you don't go through that process and you end up bringing a claim and you fail to follow the grievance procedure, then even if you're successful in your claim, you could be subject to a deduction from that claim for not following the process. So the reason for checking all of that and going through those processes is twofold. We always hope, and as employment lawyers, we often have to advise the employers on these tricky grievances, and they are sometimes highly emotional, and our role there is to try and take the emotion out of it as much as possible, which isn't always easy. But we always try the employer will always hopefully resolve the issue with the employee at that stage. Of course, that doesn't happen. And if that doesn't happen, then your first port of call, if you haven't, necessarily got the opportunity to go and speak to a lawyer directly, I would always say, and we've mentioned it before, go and speak to ACAS, both in terms of the advice, but also this the early conciliation process that I touched upon. Again, that's a sort of an opportunity to try to resolve the issue before it goes to tribunal. And then, the last resort, although unfortunately it's a resort for many thousands of employees, will be if ACAS can't resolve things, then the employee or the worker can bring or seek to bring their claims in the employment tribunal, and that will involve unfortunately, at the moment, a very lengthy process, because our employment tribunals are highly overrun and don't have quite enough staff at the moment. But that is your forum for bringing those employment or worker related disputes in this country.
Thank you so much. And James, I noticed that you had your hand up as well, so I'll move on to you before I move on to my final question of the panel.
Yeah, mine's just a really brief operational thing, which is, as Ollie says, it's as an employer, I'd always welcome someone to come to me or my HR team or whoever directly, in a really collaborative way, because if it becomes what we find and what I've noticed is that if there's an accusative manner, or the law is kind of, in layman's terms, you are walking on eggshells a lot of the time, and you're up for interpretation. And, as an employee, I don't want to say anything that puts me in the wrong lanes, so to speak. So the best way to do it is to have a really collaborative, open, non sort of judgmental conversation before both sides' shutters go up, through fear of doing something wrong or saying something wrong that might put them in a legally compromised position, if that makes sense.
Thank you so much. So we've now got 4 minutes left of the panel. So my final question is that obviously we have spoken a lot about, kind of various rights and accessibility to rights, but also one of the things that I think that has come up, especially from John, is that there isn't kind of this standardized element across the sector. You have some really great care providers, you have some who perhaps don't follow, the rules. If I could ask you very briefly, what is one systemic change that you think is needed to improve accountability and compliance across the sector? What would that be? I know, I'm sorry, James, I just saw your face and I'm very aware that that's probably quite a difficult question, but I think it's an important one. John, I'm going to go to you first, if that's okay.
Yeah, I'd say briefly it would be a workforce that is regulated and recognized as a profession, and is one that has more status than it currently has, and has responsibility for what it does, and can lead policy change and the way in which people are employed, paid, careers developed and planned, and sort of hopefully make the whole health and care service more efficient and accountable.
Thank you very much, John. Janika.
It's one that it's never going to go away, but more investment, and that comes from funding. And I know a lot of providers don't get the funding, or it's not in line with the NHS counterpart roles and things like that. But funding stability, I think, will help not only engage a better workforce and a happier workforce, but that then will also help with the other issues in respect of compliance and record keeping and logistics as well.
Thank you so much. I saw your face, James, so I don't know if you want me to leave you for last or whether you're happy to go now.
No, I'm fine to go now. I concur with both John and Janika. It's, you go back to the 30% was 35% attrition rate in our sector. That is absolutely appalling. But that's not as a result of people just being, flippant and just moving around jobs just because they fancy a change. That's to do with the fact that they potentially are underpaid. All of these things come together, and they, as John says, people need. This is a highly skilled professional sector that needs recognizing as such, and it needs rewarding as such. This is not a kind of, what has been known is that people leave jobs and go and work for, the local supermarket because it's the same pay or better pay. That's just appalling that happens when these people are trusted to look after our loved ones. And it's an amazingly professional sector that deserves that recognition. So I would say exactly those two changes. I mean, it's a bit of a cop out because I basically copied what John and Janika said, but it's true. It's money and recognition, standard stuff.
Thank you. And also, just to kind of come in from the Care Workers Charity perspective, we consistently advocate for the professionalisation of the care workforce, taking into account the skill and the value that they offer to society. So yes, I completely agree on that one. Ollie, I will go to you finally before we wrap up.
Yeah, really, really quickly, I agree with everything that's been said, and I think, leaving on a positive and hopeful note. As we said, there's lots of changes coming in employment law in this country, and the fair pay agreements that Janika explained and the introduction of the Fair Work Agency will, combine with all of those other aspects, hopefully allow for and provide for better and easier access to rights and protections.
Thank you so much. And magically, we've managed to wrap up exactly at 3 o'clock. I wanted to say a big thank you to our panelists, John, Janika, James, and Ollie, for taking time out of their day to, be part of such an important panel. And once again, a massive thank you to Freeths for sponsoring this session. As I said at the beginning, this is being recorded and will be edited and uploaded to our YouTube channel. So please don't worry if you missed out on watching it in live time. Once again, thank you to our panelists, and I hope you have a lovely rest of your day. Thank you.